Engaging a vendor client. The sixth rule of the Real Estate Agents Act, Rules 2012, outlines the requirements and responsibilities at the time of engaging a client. The rule states a licensee's fiduciary obligations to a licensee's customers must be met. A licensee must act in good faith and treat all parties to a transaction fairly. A transaction must not engage in any conduct that jeopardizes the industry's reputation. A licensee shall not deceive a customer or a client, provide misleading information, or conceal information that could be provided to a customer or a client by law or in good faith. You should obtain a copy of the property's title as a matter of course. Prior to purchasing a new listing, title verifies the tenure, ownership, and legal description of the property. Any covenants, easements specified on the title should be noted. This determines whether there are any interests or restrictions that should be disclosed to any potential buyer of the property. Prior to a listing a property, you must propose to any potential client that they obtain a buy information pack from their solicitors. You must also ensure that you provide the information necessary by law to be provided when the prospective customer signs an agency agreement under the Real Estate Agents Act 2008. This means that the agent should be licensed. Taking the vendor's property to the market. The 10th rule of the Real Estate Agents Act, Rules 2012, outlines the requirements and responsibilities associated with engaging a client. The guideline states, a written valuation of the property must be disclosed. An explanation of how the decision to sell or dispose of a property affects prospective individual advantages is required. The details of the agency agreement, including commission, must be written down for the vendor. The requirements to inform a customer of any known problems. They must also demand any potential flaws that are reasonably recognizable to be probed. If these flaws are discovered to be a problem, they must be reported to the consumer. Advertising and marketing must be tailored to the client's specifications.
Section 9.7 and 9.8 of the Real Estate Agents Act, Rules 2012, outline the regulatory requirements of an agent dealing with potential clients. These are pursuant with Section 14 of the Real Estate Agents Act 2008. These rules govern the behavior of agents when receiving offers from clients and outline the steps that they must take. Further details of these rules are provided on the slide.
Next up, we have entering into an agreement for sale and purchase with a selected purchaser. A sale and purchase agreement is a legally binding agreement between you and the other party involved in the buying and selling process. One of these must be signed in order to buy and or sell a house. It is always recommended that a lawyer overlooks the document to make sure everything is legal and binding, and also to advise whether anything should be revised. This is where a lawyer may also advise you to negotiate any of the conditions within the sale and purchase agreement, because once the agreement is signed and all the conditions are met, the deal will go unconditional, meaning the deal is locked in. A sale and purchase agreement must include the names of those involved, the address and type of property, the price as well as a deposit required, any chattels included, any specific conditions as well as how many working days to complete them, and finally a settlement date alongside the interest rate that overdue payments will incur. Finally, there are a few extra obligations to comply with. These may include, but are not limited to, access rights of the buyer, allowing them to view the property before settling. Insurance, the property should remain insured up until the settlement date, and default by the buyer or seller may result in one party having to pay the interest costs or accommodation costs of the other.
In New Zealand, it is customary for the purchaser to pay a deposit of 10% of the purchase price. They may pay it to the vendor or the agent, but it is more sensible to pay it to the agent as they are bound by legal obligations. Under Section 123 of the Real Estate Agents Act 2008, once an agent receives any money as part of a transaction, they must hold on to it for 10 working days. However, it is possible to shorten this period by either a court order or an authority signed by all parties in the transaction. Section 122 of the Real Estate Agents Act 2008 states that the agents must pay any money they have received as part of the transaction to the person lawfully entitled to it. If all conditions of the sales and purchase agreement are met, then the deposit will be sent to the vendor. If the vendor fails to meet a condition, then the deposit is repayable to the purchaser. The settlement stage is largely handled by the parties' lawyers and the agent becomes less involved. However, the agent still has a duty to act in their client's best interests, as is stated in Section 9 of the Real Estate Agents Act, Rules 2012. The agent must answer any questions the vendor has about the settlement process and make sure they know their responsibilities. The agent should arrange for a pre-settlement inspection of the property at least 2 working days before the settlement date. This allows the buyer to ensure that all of the conditions of the sales and purchase agreement have been met. Evidence of any damage or any failure to meet a condition could delay settlement. If this occurs, the agent should make sure the vendor is aware of their options whilst also communicating with the buyer's representatives to try and reach an agreement. If the agent were to discover any defects, then it is their duty to inform the buyer under Clause 10.7 of the Real Estate Agents Act, Rules 2012. Failure to do so could lead them to facing liability, as is seen in the case of Peter Hishon, when he failed to disclose that there were defective power cords in the purchaser's garage.